think we have one final argument for today. That is McKiel versus the City of Lorain. Case number 18CA011381. Both parties are present with counsel, so each side will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes if you would like for rebuttal. And if you're going to do that, let me know and I'll try to keep you appraised of the time as you get close to that. We have read the briefs in this matter and we are ready to proceed if you are.
Thank you.
I should mention that we do videotape the arguments, so we use the front podium. You can keep your voice up so we can get a good recording, especially since probably won't be able to see you with the light situation as it is. But again, you may proceed if you're ready.
Thank you, Madam. Good morning. My name is Kenneth Reesar. I'm here on behalf of the appellant. I would like to bifurcate my time and reserve 5 minutes for rebuttal.
All right, I'll let you know when you get close to that.
Thank you. We are here today on the issue of governmental immunity. Governmental immunity is governed, by the revised code 2744 or chapter 2744. Specifically, revised code 2744.02a grants a very broad general immunity to governments. The City of Lorain is a government, so it certainly applies. Then you have to look at section B of 2744.02 to determine if there are any exceptions to that immunity. The only possible exception there would be whether this would be a proprietary activity. However, the facts in this case show that that exception does not apply because it was not a proprietary function. The issue here is that the City of Lorain approved plans for a private development. That private development basically created various retention ponds, storm drains that flowed into a creek, the Beaver Creek. The Beaver Creek crosses the McKiel's property. The portion of that Beaver Creek that is across their property is actually in a designated floodplain, 100-year floodplain. The McKiel's driveway goes through that floodplain, and actually the elevation of their driveway is below the maximum elevation of the floodplain. Actually, it's about a foot below that. So that in any given 100-year flood or anything, they would anticipate that their property would flood and the water would go over their driveway. The McKiel's in this instance are alleging that because of the city's approval of the plans for the development of a piece of property, known as the Lighthouse Village property, that the city caused the flooding of their property, damaged their property, and has in fact resulted in an adverse condemnation of their property.
Was there any evidence that the city, prior to approving the plans, knew that the flow of the water or the drainage would be altered? I think the testimony was the watershed flipped. That they knew this was a floodplain and that this would be the result.
Well, there's certainly no evidence. There is when the plans were approved and there was evidence submitted that yes, the initial plans by the developer showed that the entire 70-acre development was going to flow through various retention ponds into the creek, and that a portion of that 70 acres, about 20 acres total, was actually being diverted from one floodplain, from one watershed to another watershed. However, also in conjunction with those plans, the developer of the property had to submit plans that showed that the amount of water flowing out of the retention ponds would not exceed the amount of water that was flowing from that same property prior to the development of the property. And that's in accordance with the City of Lorain's design standards.
So they had engineering data and things like that before them or not?
Yes.
They did?
Yes, the City of Lorain had substantial information, that reports prepared by the developer's engineers.
Gotcha. That
laid out all the specs, put down all the information. And the city had that, and the city had that information which, from the city standpoint, indicated that there was no problem with it, that it met the standards, that there wouldn't be any increased flow of water from that property as a result of the development.
And why did they need a bigger discharge?
Well, this happened over a period of time. There was an initial, the property is a 70-acre property, They initially started with a development for the coal store, and they put in a retention pond for that coal store, and that had a 12-inch weir in the outflow. They then developed, several years later, they developed an area, another 20 acres that included the Walmart store. When they put in the Walmart store, they put in another retention pond that flowed through to the Kohl's retention pond. And as a result of that, they then increased the size of the weir to 21 by 12 by 21. Which increased the flow of water ultimately coming out of that. That was done in 2010 was the approval, and the actual building permit was finally issued in 2011. But that only increased it to, it increased it to 30 cubic feet per second from previously, it was only 21.3 cubic feet per second or something. Increased it a little over 8 cubic feet per second of additional water that was flowing from the development into the Beaver Creek. Even at that amount, those calculations still show that it was not a problem. That it still was not increasing the amount of flow from the pre-development, total pre-development, to the post-development. Still met the guidelines. In addition, the city expert did analysis, after this case was begun, and did an analysis which showed that the actual increase in the flow of water as a result of the total development, from before any development went in until after all the development was done, was at maximum 0.03 inches increase in the flow.
That's what calculations said.
Yeah, based on calculation and simulator, and they had gone out and they had done studies of all of the size of the storms going in, the size of the creek. They did a complete analysis of everything that would go into that watershed, all the water flowing into the watershed, and its effect on the McKiel's property.
What were the genuine issues of fact that the court found in this case then?
Actually, if the courts actually appealed, the decision on the motion, it just said that there were material facts in dispute and didn't spell out anything, with respect to what those material facts were that were in dispute. There was no definitive, no statement, I'm going to say, as to what the actual disputed facts were.
There was a statement, but no analysis.
No analysis whatsoever. It is typically a lower court's denial of the city's motion for summary judgment would not be appealable, because it's not an appealable issue. But because we're dealing with the issue of immunity, well, then it is subject to immediate appeal. And in conjunction with that, there is certainly no issue here that, nothing in the pleadings even, where they allege that the city did this intentionally, that the city had knowledge that it was going to cause flooding. And there was no testimony introduced by way of depositions or anything else at the trial court level in conjunction with the motion for summary judgment to that effect. They have only said that their property floods more now than it did before the development, but they have not submitted any evidence that actually showed that the city was responsible for that. It just, as I indicated in my brief, just because there may be a correlation, that doesn't show causation. They have the duty to show the causation. We submitted evidence through our expert and our engineer that their city did not cause any flooding, that the development, first of all, the city didn't do it. All the city did was approve plans. The city doesn't own the area. The city didn't construct the retention ponds. City didn't construct the sewers. The city doesn't maintain the sewers. Those retentions, the city has nothing to do with it whatsoever.
So do they just rubber stamp when somebody presents a plan, they just stamp it and say, go ahead and do it? Or do they have some obligation to look at that?
They have an obligation to look at it,
Okay.
which they do, and they look at it. But they, honestly, they certainly rely upon the developer's engineer. Because the developer's engineer, whenever they submit it, they have to certify that their numbers are correct and that they've done an analysis and based on those numbers that they're appropriate. But the city engineer does review that before they say, yes, this is okay. And in this instance, the city did that, the city approved it, and that was it. That city has no other involvement in it. the evidence also submitted at the trial court shows that the government doesn't own it, the property. The government doesn't maintain the property, the retention basins, and it was uncontested that it's not a part of the city's stormwater retention system. This is a private developer, got approval for plans, but the private developer designed the system, constructed the system, maintains the system, and it goes directly from the private developer's land into the Beaver Creek. The testimony before the trial court was that the Beaver Creek is not a part of the city's storm sewer system. Therefore, the government is not the beneficiary of this. The government, meaning the city of Lorain, hasn't taken their property. And one of the reasons here is that their allegation is that it has been a government taking of their property. There hasn't been a government taking, and they can't prove a government taking. The city of Lorain is not getting a benefit from this. It's the private developer. The city of Lorain did not take that person's property. The city of Lorain is not maintaining it. If there is any issue here, it's an action by the McKiels against the private developer. They're the ones that are doing this, not the city.
You're at 4 minutes and 38 total time left. I don't know if you can continue if you'd like.
No, I'll
You want to reserve that? Okay.
Thank you.
Counsel, are you okay standing up? I can see that you have a cane with you. Are you more comfortable staying at the table?
I don't mean to be disrespectful. If you wouldn't mind me sitting, I would appreciate it.
I mean, if you keep your voice at that volume, we can hear you.
Okay, thank you very much, Your Honors. I appreciate it very much.
You have 15 minutes.
Thank you. If I could begin kind of backwards, forwards, where counsel left off. First of all, the city of Lorain's engineer, I don't understand why council would say to you that the city is not responsible for its sewers. All waterways in the city of Lorain, within the municipal boundaries of the city of Lorain, are the responsibilities of the city of Lorain's city engineer. The city of Lorain's engineer is responsible for all drainage, stormwater drainage systems, including the North Fork of Beaver Creek. That's in the revised code. The county engineer does not have the jurisdiction over the streams within a municipality. It is the city engineer. And I would cite to you the famous case in Ohio of the city of Lorain versus Maisley, which has been cited to this court, I believe, in our briefs, which outlines the fact that the city of Lorain has firsthand knowledge of the fact in the Windsor Court debacle, where they flooded out the Windsor Court people by making the Beaver Creek overflowed by stormwater drainage, and they ended up, the city in that case had to buy out the entire subdivision because of the way that they treated stormwater drainage in that area. That was back, I think Norm Beller was associate counsel for the city, along with Ralph, the gentleman's name escapes me at the time, but that was when John Ritzko was the law director. And they ended up, I believe Mr. Corey was one of the prosecutors at the time. But it came down to the fact that the city of Lorain learned an expensive lesson that you can't dump stormwater on people, flood them out by way of using an existing creek, which was the Beaver Creek, further down the line in this case. Now in this case, mandamus is what the McKiels must use. I mean, in Ohio, regulatory taking. What does the city of Lorain believe it is when you change a watershed? When you go ahead and change what God created in the city of Lorain's geographical area. You had, as Michael Zunich, our engineer, put in his affidavit to the court. He very clearly said that when the land broke originally, about 40% of the land in its original condition flowed to the northwest. When the rains fell, it flowed to the northwest. And only a portion of the property drained back towards the McKiel's property. In comes the city of Lorain and the developers, and they said, well, you know what, we're going to bring in the Walmart, we're going to bring in the Kohl's, we're going to put this commercial development in what used to be a what we consider an eastern rainforest, pristine rainforest, that would, wetlands, and all of a sudden we're gonna denude the forest, we're gonna put in this parking lot, the commercial buildings with all the commercial roofing, we're gonna collect all this water immediately, we're gonna put it on that parking lot, we're gonna put it on them commercial roofs, pipe it, we're gonna throw it into these retention basins, then we're gonna drain it, we're gonna put it right through piping systems, and we're gonna accelerate the flow and drop it into the North Fork of the Beaver Park, and then we're gonna only put it through an 11-inch tile, but now they've expanded it, you heard council admit it, now they've expanded it out to 22, 23 inches. So not only have they collected it and drained it into the North Fork, but they've dumped all that water coming across the land, and it accumulates right through what they've admitted was a floodplain. So they said, we know it's bad to begin with, but we're gonna make a bad situation worse, okay? And council has admitted it. I'm glad you're taping this, because all those statements that he's made here today is an admission of intentional behavior on behalf of the city. That they knew that it was a bad situation and they were gonna make it worse, okay? Now, that in and of itself shows that they knew they needed to take a perpetual easement across the McKiel's property to accept this additional flowage of water, okay? So, what is the McKiel's, this is an appropriation of land. And why is it a taking? It's a taking because the McKiel's have an expectation that if their land is going to be taken, that they get compensated for it.
What evidence was there that, in fact, the land was taken, that there was a serious flooding issue?
Oh, well, I'm glad you asked that, Your Honor, because in the record itself, you have videotape, you have a video disc, which I implore you to please look at when you'll see the flooding. It comes almost up to their residential property.
All right, I guess my question was more
There's
so,
pictures, there's video.
what evidence was there that the cause of that flooding was from the city? Was there
You see the
engineering
water.
reports? Was there?
You see water, you see pictures of the
Again,
flooded.
I'm not disputing, I asked the question the wrong way. My question is, what is in the record that connects that flooding to the city, that shows us that the city caused that flooding? Are there engineer
Yes, you
reports?
have McKiel's engineer, Michael Zunich, who testifies about what he observed pre-conditions and post-conditions of the engineered drawings, and what existed before the engineered project was done. The way that the water flowed before to the way that it flows after. And the fact that this additional drainage created a burden to the McKiel's property, that there was increased flow. And he describes the additional flowage.
He described this in an affidavit?
Yes, in an affidavit, the engineer's affidavit. Plus, I would also assert to the court that all of the city's engineered evidence demonstrates our position. That there was an increase in a burden, an additional burden to the McKiel's property. I mean, it actually helps our case. It demonstrates that there was additional burdens put upon our property. You know, the fact that the city describes in its briefs to the court as a de minimis burden, that's ridiculous. When you look at the photographic evidence, it is not de minimis. I mean, you've got to have a red face. You can't even say that to a red face case when you take a look at the fact that they can't use their bridge, that the stone and gravel in their driveway gets washed out, that their supports are being undermined and washed out, the erosion, the trees that are being knocked over, the fact that they have to sit there and wait several hours every time it rains more than an inch. I mean, the testimony of Mr. and Mrs. McKiel, who've lived there for almost 50 years, that before these shopping centers were built, they never had this kind of flooding. They're having 500-year rain events now, like every other year. I mean, that they're being, if they had to get an ambulance into their driveway, the firemen said, well, we won't even drive down there. Their propane delivery man won't even come down their driveway. It's not safe. They don't have access like they used to have just to their home. Mr. McKiel runs a repair shop out of his garage. His customers don't want to drive down his driveway to come to his home anymore because they're elderly and it's not a safe approach for them. He has significant issues because of what they are doing by this taking.
What obligation does the city have when plans are presented to them? What requirement does the city have to review those plans? What's their standard that they have to look at?
They have an obligation to be fair. They have an obligation to notice the neighbors that are going to be affected and to go out and talk to them and say, look, this is going to have an effect upon your land. And therefore, we need to acquire a permanent easement across your property and to mitigate what damages. And under revised code 163.2, we have an obligation to acquire that drainage easement. And then you go through the requirements of revised code 163.02a, and then there's a whole series of things that they must do in order to accomplish the appropriation, which is all contained in 163.01 through 163.22. They have to go through an appropriation proceeding.
But I'm talking about before, when the plans from Kohl's and Walmart, everybody, the Lighthouse, whatever, is this company.
They have to notify the neighbors that are going to be affected. There should be a notice sent out. There should be an administrative proceeding, a hearing. There should be some type of effort to notify not only of the zoning changes, but of the planning changes of how this is going to impact you as a neighbor.
So are you stating that the city never did that?
They never did. Nobody from the engineering department ever came down. And in fact, when Mr. and Mrs. McKiel had notice of a street improvement project that was going to take place, and they were provided notice of the need to accumulate or take part of their land for street improvements, Mr. and Mrs. McKiel brought up the fact that they were worried about water issues, and nobody from the city, even though they were put on notice by the McKiels of the water problems that they were being anticipated, nobody from the city came back and told them about any of these engineering scenarios that the city intentionally knew that was going to happen. Nobody came to them and said, well, these are what we have in front of us. It wasn't until Mr. McKiel's engineer went down and discovered what was going on that they first learned that they were going to have all these engineering scenarios that were going to be dumping water upon them. Nobody came and disclosed to the McKiels until the McKiels actually had to pay an engineer to go down and discover for themselves what the impact of this development was going to be with respect to the water issues from that development. The city never volunteered anything to them. I think the city was more interested in getting the development moving than it was to acquire the required perpetual drainage easements. But to go back to the argument of the city that somehow or another they have immunity under revised code section chapter 2744, I would need to let you know that 2744.09F itself, the statute itself says there is no immunity for civil claims based upon alleged violations of the Constitution or statutes of the United States. Our mandamus action says, hey, we've got claims under the 5th Amendment to the United States Constitution and the 14th Amendment of the United States Constitution. And the United States Supreme Court, as we sit here today, is going to be issuing a ruling, probably in October of this year, that talks about the 5th Amendment having an independent right where you don't have to exhaust all your administrative remedies before you actually can bring an action in federal court directly under the 5th Amendment. So, I hope that you're aware of that, because this is an important case of the McKiels. We have a right under the 5th Amendment of the United States Constitution and the 14th Amendment to be able to bring this action. But under Ohio law, as it exists today as we sit here, a mandamus action is required, and that's what we brought, to try to enforce those rights. And Chapter 2744 provides the city of Lorain no immunity, none whatsoever, except to allow them to bring this as a delay against our mandamus action. And further, we also have the Ohio Constitution. Article 1, Sections 1 and Sections 19 provides a direct cause of action for us against the city of Lorain. And a revised code section, chapter 2744, and any of its subparts, cannot take away our constitutional rights under the Ohio Constitution. The General Assembly of the state of Ohio has no right to deny our constitutional rights in the state of Ohio to be compensated for the taking of our real estate. This is a fundamental right of an Ohio citizen. And Mr. and Mrs. McKiel are property owners. They own 4 parcels of land that are being affected by this taking of a perpetual easement by the city of Lorain. And so we're here asking you to please do not recognize this, what I would argue respectfully, counsel, as a fraudulent assertion of immunity from this, really a destruction of property rights of my clients. We just can't allow it. A citizen has to be protected, and God help us all if the city of Lorain can just bull rush us and take away our rights. I believe I've covered all my things. Oh, one point that I did not cover.
You got about a minute, so,
I'm
1
sorry.
minute left.
Under Revised Code Chapter 3767.13c, it reads, "No person shall unlawfully divert a water course from its natural course or state to injure or prejudice others." And in Chapter 2744, there's a provision that says that the political subdivision is not immune if it violates other sections of the Ohio Revised Code. And I assert to you that there can be no immunity argument where the city of Lorain violates 3767.13c by changing the natural water course by its regulatory behavior. And that's exactly what they did. When they changed God's plan for the water course, and they shifted and they changed the way that the water is going to flow, they violated that revised code section. And they created, really, if I did it or you did it, it would be an environmental crime, and the Ohio EPA would come out and put us in cuffs and lead us away. But because the city of Lorain does it, they claim that that's, oh, we're immune, you can't do that. Well, I object, and I say that the king has committed an environmental crime and shouldn't be allowed to claim immunity. Thank you very much.
Time with that, so, thank you. You'll have 4 minutes and 38 seconds for your rebuttal, counsel.
Thank you. As I indicated in my reply brief, therein, counsel for McKiel's makes reference to numerous things, numerous statements that are not in the record before the trial court. And I'm not going to get into it, but about 75% of the facts that he was reciting are not part of the trial court record. With respect to the case of Massley versus the city of Lorain, it was not dealing with the Beaver Creek. It actually was dealing with Martin's Run, which is a different waterway. But in Massley, there was this distinct difference because the city in that case stipulated that it in fact had created and built a storm sewer system, and that Martin's Run was in fact a portion and incorporated into the city's storm sewer system. And that the city also stipulated in that case that as a result of the creation of the city's storm sewer, which the city built and was on city roadway and stuff, that it actually did increase the flooding in Martin's Run. So the Massley case, the facts in the Massley case are totally different than the facts in this case. In this case, the city has not, the facts before the trial court show that that the city did not cause any increased flooding. I mean, even the approved plan for the Lighthouse Village, the actual facts show that there was no increase in flooding as a result of the stormwater coming from that development. With respect to Mr. Zunich, who is the McKiel's expert, his original affidavit that was submitted with his their motion for summary judgment referenced letters that he had written in 2015, with respect to the diversion of the watershed and the amount of flooding that was occurring, the additional water that was going in. At his deposition, Mr. Zunich actually indicated that he had, by that point in time, had seen the plans, had gotten more specific information, had read the expert report that was provided by the city's expert, Mr. Moniz, and he agreed with the city's report. He said that the conclusions were correct, the findings were correct, and that realistically, there was nothing more than a de minimis increase at best in the amount and flows coming from the developed property into the Beaver Creek as a result of the development. So when he's referring back, when council was referring back to an affidavit, that is disingenuous, because Mr. Zunich, at his deposition, and actually in my brief, completely contradicted his prior affidavit, agreed with our expert that there really was no increased flooding caused by the city, and the McKiels introduced no evidence whatsoever before the trial court that the increased flooding of their property was caused by the development. They have stated, yes, there's increased flooding, but they submitted no evidence as to what the pre-development flows were, how those flows actually affected their property, other than the fact that they say, we now flood.
What about the videotape or CD that he's talking about?
Oh, there's a CD, and it shows flooding, it shows water going over his bridge. It's certainly there, but as I indicated earlier, the designation of the floodplain, that is done by the federal government, the last one was done in 2008, this is before the development. And it already showed that there was a 100-year floodplain in this yard, and that his roadway was below that, was a foot below the roadway.
Was there an affidavit accompanying the CD that indicated that?
Well, he said, well, they say this is
What caused?
This is what it, no, not what caused it. This is what it looked like in 2014 when there was it wasn't only a 100-year flood, but our evidence that we submitted with that showed that it was basically a flood event that was in excess of a 100-year flood. The newspaper articles at the time indicated that it was a 500-year flood event.
So it's only ever flooded once there then?
Well, no, it's only flooded really bad once, as far as I know. They have had other events where the water has come up and it's gone over their roadway, yes. But it's not, to my knowledge, it only came out of the floodplain one time, to my knowledge.
Thank you for that answer. If you're out of time, though.
Okay, thank you.
Thank you both for your arguments today. The court will take the matter under advisement, and we will issue our decision in due course. The clerk of courts will mail you both a copy of the court's decision once it's released. You can also check out the Ohio Supreme Court's website, which also where our decisions are also posted. But thank you both for your